My mother's key slid into the front door, but the lock would not turn. She tried again, harder this time, then looked at me with a kind of confusion I had never seen on her face before. Taped to the glass beside the door was a white notice claiming the property had been secured under a court order. My mother had owned that house for 23 years, yet there had been no foreclosure hearing, no sheriff's sale, no writ of possession, and no judge had ever ordered her out. And yet, someone had changed the locks while she was away for 5 days. 4 months later, the HOA president who authorized that lockout would no longer be president. The lien against my mother's house would be released. The security company would rewrite its residential lockout policy, and county investigators would be reviewing how a document that looked like a court order had been used when no matching order existed anywhere in the docket. But standing on that porch, none of that had happened yet. All we knew was that my 74-year-old mother could not enter her own home. My name is Evan Cole. I was 46 then, and I managed an auto parts store. I was not an attorney, I did not know anyone at the courthouse, and I definitely did not know enough about foreclosure law to start making accusations on a front lawn. So I did the simplest thing I could. I documented everything by photographing the new deadbolt, the notice, the judge's name printed near the bottom, the supposed court seal, the case number, the locksmith sticker on the doorframe, and the private security SUV parked across the street. Then I called the sheriff's non-emergency number, and while we waited, HOA President Lauren Wexler came walking up the sidewalk. Lauren was 58, tall, polished, and dressed in the dark pink business suit she seemed to wear whenever she wanted everyone around her to remember she was in charge. She carried a burgundy folder against her chest and told us the association had acted under court authority because my mother had ignored collection notices, prompting me to ask her for a certified copy of the order. She merely pointed at the paper taped to the door, which was not what I had asked. When Deputy Harris arrived, he studied the notice and asked Lauren for the case number, which she gave to him confidently. He entered it into his computer, then looked back at the paper. The number did not match the normal format for civil cases in our county. That alone did not prove anything, but it was enough to make him start checking, and once he did, Lauren's certainty began falling apart, one record at a time. My mother's name was Margaret Cole, and she and my father bought the house in Briar Glen in 2003, back when the neighborhood still had empty lots and young trees tied to wooden stakes. My father died 9 years later, but Mom stayed, because the house was not an investment to her. It was home. The maple tree in front had been planted the year my niece was born, and the dining room baseboard still had a dent where Dad once tried to move a piano by himself. Mom knew which neighbors had grandchildren, which ones traveled every winter, and which ones needed their mail picked up when they were away. She had paid off the mortgage. She paid her property taxes, and until the dispute started, she had never been more than a few weeks late on an HOA assessment in 20 years. The problem began with a hedge after Mom had knee surgery, when part of the greenery along her front walk grew above the height allowed by the landscaping rules. The first violation was legitimate, so she hired a gardener and fixed it, but the account inexplicably kept growing. There was a follow-up inspection charge, then a late fee, then another administrative fee, followed by attorney collection charges tied to notices Mom said she never received. By the time I got involved, the HOA claimed she owed $3,840. Mom did not say she owed nothing, but she fiercely disputed how the account had grown from a landscaping problem into almost $4,000. She asked for an itemized ledger, copies of the notices, and requested a hearing. Lauren treated every request like an attempt to avoid responsibility, and at the hearing, the board reduced one fine but left the collection charges largely intact. Mom paid the portion she agreed was valid and continued disputing the rest, but several months later, the HOA recorded a lien. That word scared her more than anything else had, and she called me crying because she thought it meant someone could immediately take the house. I helped her speak with a local attorney, who explained something vitally important. A lien was serious, but it was not the same thing as an order giving the HOA possession. If the association intended to foreclose, it had to follow the legal process available in our state, which meant there would be filings, formal notice, an opportunity to respond, and additional steps before anyone could lawfully take control of her home. None of those things had happened. Then my sister invited Mom to stay with her for 5 days while some flooring work was being done, and I picked Mom up when she returned, which was the very afternoon we found the changed lock. If you have ever had someone wave an official-looking document at you and expect you to stop asking questions, tell me in the comments what you would verify first. And share this story with someone who owns a home, because what nearly worked against my mother was not legal authority. It was the appearance of legal authority. And Deputy Harris was about to test the difference. Deputy Harris asked dispatch to check for an active civil order tied to my mother's name and address, but nothing appeared. He then contacted the clerk's office through the verification channel available to law enforcement, and still found nothing. Lauren insisted the paperwork had come through the HOA's legal process, so Harris asked if she had a writ of possession, a foreclosure judgment, a sheriff's process number, or a certified order, which she did not. Then he spoke with the private security supervisor, and that man admitted his company had not received anything directly from a court, as the HOA management office had sent the instructions, and the locksmith had been hired the exact same way. Harris did not try to decide the entire HOA dispute from the driveway, nor did he say the lien was invalid, or rule on whether Mom owed money. He simply focused on the immediate issue. Could anyone there show verified legal authority allowing the HOA to deny the homeowner access to her own residence? They absolutely could not. The HOA's outside collection attorney was called, but his office would not confirm that it had obtained any possession order. Within 40 minutes, the locksmith returned, looking uncomfortable from the second he stepped out of his van, and with Deputy Harris still present, he removed the replacement cylinder and restored Mom's access. I expected that to be the end of the immediate crisis, until we went inside and realized someone had entered the house. There was an inventory sheet on the dining table, a numbered sticker had been placed on the refrigerator, several cabinet doors were open, and a note on the kitchen counter referred to the property as secured. Nothing obvious was missing, which almost made it worse. Mom stood in her kitchen, looking around at evidence that strangers had walked through the rooms where she had lived for more than 2 decades, and then she sat down and cried. That night I backed up every photograph and video, and the next morning I called Maya Patel, a real estate attorney who handled HOA disputes. She reviewed the lien notice, the paper from the door, the sheriff incident number, and the photographs, but she did not begin by talking about damages. Instead, she asked where the supposed order had come from, and we did not know. Then she asked what the board had actually authorized, which we did not know either. So Maya immediately sent preservation letters to the HOA, the management company, the security contractor, and the locksmith. She requested board minutes, emails, work orders, security reports, entry logs, collection records, and every single copy of the document used to justify the lockout. The first major break came from the HOA's collection lawyer, whose office confirmed that it had recorded the lien, but it had not filed a foreclosure lawsuit. It had not obtained a possession judgment. It had not ordered a locksmith to enter my mother's house, and it certainly had not created the document taped to her door. That changed the entire case. The HOA had been telling contractors it possessed court authority that its own collection attorney said he had never obtained. Maya started with the court docket, confirming there was no foreclosure action under Mom's name, no possession case tied to the address, and no case matching the number printed on the notice. The judge named on the document was a real judge, which probably made the paper seem convincing to anyone who saw it quickly. But the date created another massive problem. The judge had been assigned to an entirely different civil division during that period, and the clerk's office eventually provided written confirmation that no matching order had ever been entered. Then Maya compared the paper from Mom's door with genuine county orders, and the differences were small, which was exactly what made it so disturbing. The case number contained an extra digit. The filing reference field normally used by the clerk was missing. The signature looked like an image placed onto the page rather than the court's standard electronic signature format, and the footer referenced an older version of a court form. This document was not simply an HOA letter with dramatic language. Someone had deliberately made it look like judicial process. Next came the board minutes, which showed the directors had authorized the collection attorney to pursue lawful remedies for delinquent accounts. And that was all. There was no vote authorizing possession of Mom's house, no authorization for a locksmith, no vote allowing private security to inventory her belongings, and zero record that the board had ever been presented with a possession order. Then Maya found an email chain where the community manager had asked Lauren whether the attorney had approved securing Mom's property, to which Lauren replied that the association already had judicial authority. Attached to that email was the exact same PDF later taped to the front door, which the manager then forwarded to security and the locksmith. That explained how the paper traveled, but not where it came from. The security company's records showed that its supervisor had asked for a sheriff process number or court contact before entering, but the management office responded that Lauren had confirmed the legal authorization and that counsel had already handled the underlying matter. The supervisor should have independently verified it, a fact the company later admitted, but the message also unequivocally showed the false premise had originated with the HOA. The locksmith's work order was even clearer, describing the job as a court-authorized HOA possession, and the only authority attached to the order was Lauren's PDF. Then a later document production contained the original digital file, and its metadata showed it had been created from a word processing file associated with the HOA management office. The file name actually included the words "possession order template," and while that did not tell us exactly who typed every sentence, it made one thing impossible to deny. The document had absolutely not been downloaded from the county court system, as Lauren had implied. Maya sent the clerk confirmation, the source file information, the email chain, and the locksmith records to the HOA's insurer, and she also provided them to the sheriff's investigator assigned to the supplemental report. By then, the landscaping debt was almost secondary, because the bigger question was how a private association had used something designed to look like a court order to gain entry into an elderly homeowner's house. The legal reversal was much simpler than the document itself. The HOA did have a lien, and nobody disputed that, but a lien was not a judgment giving the HOA the house. It was not a writ of possession, it was not a foreclosure sale, and it certainly did not authorize Lauren to skip every legal step between recording a claim and taking physical control of the property. Maya laid that distinction out for the board, explaining that while the HOA could pursue legitimate collection remedies, it could not manufacture the appearance that those remedies had already produced a court order. Then the county clerk's written verification arrived, proving that no such order had been entered, no matching case existed, and no court had ever directed the HOA, the security contractor, the property manager, or the locksmith to remove Margaret Cole from possession. That single confirmation destroyed the foundation of the lockout, prompting the HOA's insurer to appoint separate counsel. The management company instantly froze Lauren's authority to give vendors possession-related instructions, while the locksmith announced it would perform no further HOA rekeying without independently verified court documentation, and the security company did the same. The sheriff's office opened an investigative referral concerning the document, and while nobody arrested Lauren on the front lawn, nobody pretended the criminal or administrative side could be resolved in a day either. Investigators collected the PDF, the metadata, emails, work orders, and statements from the people who had relied on it, and the matter was forwarded for appropriate county review. For Mom, the civil case moved much faster, as Maya demanded a complete accounting of her HOA balance, the removal of every charge created by the lockout, and full reimbursement for the door and locksmith costs. She challenged attorney fees tied to defective notices, and she demanded that the lien be corrected or released once the legitimate balance was resolved. This time, Lauren did not answer. The association's new counsel did. The woman who had spent months telling my mother she had no choice was simply no longer controlling the file. The insurer's investigation pulled the different pieces together, and the collection attorney produced his complete file. He had sent demand letters and recorded the HOA lien, but he had never filed a foreclosure complaint. He had never requested possession, and he had never authorized anyone to enter the house. That completely eliminated the last plausible argument that Lauren had simply misunderstood something her lawyer sent, and shortly after, the corrected account ledger arrived. It turned out several fees had been duplicated, and 2 collection notices had been mailed to an address the management company knew was outdated. While some attorney charges remained valid, others were removed, and the $3,840 balance dropped dramatically. At a special HOA board meeting, residents learned that a possession document had been circulated, even though no matching court case existed. Lauren tried to describe what happened as a procedural misunderstanding, but when one director asked whether she had personally sent the PDF to management, she had to admit she had. Another asked whether she had verified it directly with the collection lawyer before sending it, and there was absolutely no email, letter, or call record showing that she had. Then the board reviewed the minutes, confirming they had never authorized a lockout. That evening, the directors voted to remove Lauren as president, and though she remained temporarily on the board while council completed its review, she immediately lost all authority over vendors, collections, and management instructions. The HOA adopted an emergency procedure requiring attorney verification before any action supposedly based on a court order, and the security contractor changed its procedures too. Its employees could still enforce access rules on common property, but they could no longer participate in residential lockouts simply because an HOA officer handed them legal-looking paperwork, and the locksmith company instituted a policy requiring independent verification of judicial process before any similar job. Meanwhile, Maya flawlessly negotiated Mom's settlement, where every lockout-related fee disappeared, the locksmith and security charges were removed, and improper late charges were canceled. Mom paid the remaining undisputed assessment and legitimate portion of the account, and in return, the HOA recorded a release of its lien. When Maya handed Mom a copy of the recorded release, that was the very first time I saw her smile about any part of the case. The fake-looking paper had locked her out for less than an hour, but the lien had frightened her for months, and seeing that release truly mattered more than watching Lauren lose a title. The HOA paid to repair the front door and reimbursed a negotiated portion of Mom's legal expenses, while Lauren quietly resigned from the board before the next annual election. The county's review of the false court document continued separately from our civil settlement, which was exactly where that issue belonged. Mom stayed in her beloved home, replaced the hedge that had started the entire dispute, and bought a small fireproof document box for the paperwork she never wanted to hunt for again. Inside it are her deed, the corrected HOA ledger, the recorded lien release, and the clerk's letter confirming that the supposed possession order never existed. What bothered me most was how convincing the paper looked. It had a judge's name, a seal, a case number, and formal language. It was enough to make a manager, a security supervisor, and a locksmith assume someone else had already verified it. But legal authority is not created by formatting. The docket mattered, the clerk mattered, the real legal process mattered, and once we checked those things, The entire story the HOA had built around that document collapsed. I did not help my mother by breaking her door down or threatening anyone. Instead, I took photographs, I called the sheriff, we checked the case number, and then we followed the records until the truth was stronger than the paper taped to the glass. If you came home with your mother and found her locked out of the house she owned, tell me in the comments what you would verify first. Share this story with someone who owns a home. Save it as a reminder to check any legal-looking document before accepting it at face value. And subscribe for more stories about ordinary homeowners protecting their property with evidence, patience, and the law.